and you can make a difference.
Christians do bring an element of salt and light to contemporary affairs.
Our Lord said that we were to be in the world and not of the world.
If we as Christians will allow God to melt our hearts, the same fire that is melting us will melt those around us.
My assigned task is to explain how the law, for better and for worse, is shaping our life and death decisions today. To illustrate my remarks, I will be using the case of our more than 150,000 unchosen and frozen human embryos, and how their rapidly growing numbers as the result of the growing and largely unregulated IVF industry present both the opportunity to develop legislative guidance at the state and federal levels most protective of human life, and an irresistible temptation to again reopen the Pandora's box of destructive human experimentation last opened in the Weimar and National Socialist period of German history, just in the middle of this century. At the conclusion of my remarks, I will invite you to make a difference yourselves by joining Do No Harm, the Coalition of Americans for Research Ethics, CARE. You might call it an antidote for cure. This growing national coalition of patients, researchers, healthcare professionals, bioethicists, legal professionals, and others dedicated to the promotion of scientific research in healthcare, which does no harm to human life, while advancing legally and ethically responsible science, healthcare, and public policy. This group is essentially guided by the principles set forth in this statement on human embryos and stem cell research, which you have in your packages and is outside for your purview and signature. We're asking you to read it and sign it and get others to do the same. Read it, sign it, get others to do the same. To get us started, let us welcome to our stage the players, without whom this bioethics conference, Making a Difference, would not be possible. Christians sometimes think of them as Luke, the physician, and Paul, the lawyer, but we will use their other names. To my right, we have Dr. Asclepius, our currently proud, but sometimes befuddled symbol for medicine, holding his chart of inquiry and his test tube full of life. He rarely has time for justice, but she just won't leave him alone. To my far right, we do have Lady Justice, our currently blinded symbol for the law, holding her scales of equality, which are to reflect the dignity of all human beings before the law, and her sword of judgment, judgment for life or death. She occasionally uses her sword rather than her reason to find her way. And she is not nearly as blind or as unbiased as people think or hope. She is attracted to Dr. Asclepius and has trouble leaving him alone. She so wants him to like her. He wants her to just leave him alone. Medicine and law currently do have a problem. They do not agree when human life begins. They neither trust nor understand each other very well. Power and technology and fear throw them together all of the time. Their practitioners are frequently accused of that dreaded M word by their patients or our clients. Both are confused about their own identities and appropriate powers. Their problem is not new. The older version of their story is that Lady Justice only gave Asclepius a life-preserving vial, reserving the power of destruction for herself. Why else, says Lady Justice, do you think I am still carrying around this sword? But the more modern version of their story is that Lady Justice gave Asclepius, the revered founder of medicine, 2 vials. One did provide protection against death, and the other, a deadly poison. Lady Justice also lets Asclepius take her sword as well, from time to time. According to Dr. Leon Cass of the University of Chicago, there is force to both accounts. The first shows that wisdom would constitute medicine an unqualifiedly benevolent, i.e., intrinsically ethical art. The second attests to the so-called moral neutrality of medical means and of technical power generally, so easy to lose the ends in the extravagance of the means. Hippocrates, the inspiration of medicine's Hippocratic Oath, still administered, I'm told, in more than 95% of our medical schools, favored the first version when he wrote in the Epidemics, "As to diseases, make a habit of 2 things: to help, and at least do no harm." Do no harm. Today we doubt that medicine is an intrinsically ethical activity, but we are quite certain that it can both help and harm. In fact, today, help and harm flow from the same vial, the same respirator that brought a woman back from the edge of the grave just last week, as I was reading in the Los Angeles Times, also senselessly prolongs the life of an irreversibly comatose man, as that man's family thinks about what to do. The same morphine that reverses the respiratory distress of pulmonary edema in my mother last year, in higher doses arrests respiration altogether. Whether they want to or not, doctors are able to kill quickly, efficiently, and surely. And what is more, it seems that the law, particularly judge-made law, is letting doctors kill more often and more openly. Why? If we can understand the why, perhaps we can understand the solution. As far as I can tell, the why is one of 2 reasons. First, either to protect the autonomy, what Sir Brian last night referred to in that wonderful British accent as privacy. We would say privacy. Or, if not privacy, at least the liberty rights of their patients, quote unquote, in the case of abortion and physician-assisted suicide. And the other reason is quite different, where the focus is not on the patient, but on the doctor, the researcher themselves, celebrating their allegedly humane and compassionate motives. This is true in the cases of abortion, euthanasia, IVF, pre-implantation embryonic screening, or destructive human embryonic stem cell research. We see this currently when people say we've got to do this research, otherwise others will die. It sounds, and the people who say it do believe, that they are quite compassionate. So much for medicine. Law, of course, is not without her problems. As you can see in this area, she is quite willing to leave her scales on the stage, and her biases are showing. As she runs after the power, she is turned over to technology. 15 years ago, John T. Noonan, the most respected pro-life legal scholar in America, published his justly famous essay, The Root and Branch of Roe v. Wade. A Roman Catholic writing in the natural law tradition, Noonan found the root of Roe to be the positivist belief that the sovereign, and we've seen the sovereign here, has an absolute right to define who counts as a person with rights. Under this positivist view, the law does not need to correspond to reality or nature. A human being could at will be relegated to the legal status of real estate, kitchen utensils, or livestock. Noonan noted that the eminent lawyers such as Thomas Jefferson and even our own Abraham Lincoln, otherwise known as a great freer of the slaves, had engaged in these sorts of characterizations in relation to slavery law as they protected the rights of the personal property owners. The law, Noonan argued, became a, quote, mask obliterating the human person. Noonan argued that Roe and its progeny had used the law as a mask to avoid perceiving, quote, the reality of the extraordinary beauty of each human being being put to death in the name of the abortion liberty, end quote. As we will see later in my remarks, the extraordinary and unique beauty of the human being in his or her embryonic age is now being put to death in the name of the research liberty. Noonan described the branch of Roe as the Supreme Court's invention of doctrine unconstrained by the text or purposes of the United States Constitution. Noonan called such doctrine, the abortion right in this case, quote, the fantasy in service of ideology. This branch was a reflection of the positivist logic, which, in Noonan's words, quote, permits the judges at the apex of a system to dispense with correspondence to reality. The positivist root permitted the justices to declare human beings, quote, non-persons, end quote. The positivist branch permitted the justices to invent constitutional doctrines without regard to the Constitution. In both instances, positivism gave justices the right to shape law with no correspondence to reality. If there's one thing that I think believers in Jesus Christ do wherever they are salt and light, it is they bring people back to a one-to-one correspondence between truth and reality. This is a function of light. Whenever we allow there to be no correspondence between truth and reality, we are not salt and light. Insofar as the declaration of the abortion right also patently contravenes the will of the people, as expressed in the legislative enactments of the several states that were nullified by Roe and its progeny and have subsequently been nullified by Roe and its progeny, such legal positivism has also been critically referred to more recently as the judicial usurpation of democracy. Noonan believed the natural law, properly understood and applied, could serve to prevent the evils created by positivism's absolute view of state power. However, as we were reminded last night by Sir Brian, one of the problems with Christianity is we're always riding our hobby horse, but we don't look at the implications of what we're doing and saying. And I would like to broaden us a little bit here, at risk of my popularity. A decade later, it has been suggested that the absolutisms of the anti-abortion movement have also led to death. Murders of physicians and others involved in the provision of abortion services. Please do not get me wrong. There is no doubt that Noonan and the overwhelming majority of those who share his views morally condemn those killings as certainly as they condemn the killings of the unborn. Nonetheless, it is not enough for those of us who believe in moral absolutes to condemn these murders or to point out the obvious incongruities involved in the killing in the name of life. The more profound questions, which I think Christians always have to be in the forefront of asking, concern the role that a claim of moral absolutes can and should play within legal and public debate. Noonan and the natural law tradition he represents warn of the dangers of absolute tyranny posed by positivism. The countercharge is that claims based on natural law themselves possess an absolutism that can also be dangerous. Never forget, dear Christian brother and sister, to look in the mirror and see yourself. Any answer to these questions must begin, as I've thought about it, with an understanding that what we really have here, as we said here in this little skit, two versions of the same story, what we really have here is competing concepts of law, and hence competing concept of what we mean when we say lawless. Competing concepts of lawlessness are at the root of the life and death decisions confronting the law today. The concept of law we adopt will direct how the law shapes our views of the issues, and indeed are already shaping our views. On the one hand, positivism finds lawfulness to stem from consent, the priority of the right over the good. Means that a system is legitimate if it grants moral autonomy to individuals. Individuals have the right not to be coerced without their consent. Thus, particularistic religious and moral claims are not sufficient to legitimize either the political system as a whole or particular legal rules. We heard Sir Brian last night give us a politician's perspective on that very point. Sir Brian told us, and I will tell you again, both must be justified by public reasons or reasons accessible to all. I will stop right now. I'm sure as you walked in today you were confronted by some horrible pictures, but truthful pictures. On display out there are very public reasons accessible to all. Very few of them rely on any special revelation. Particularistic religious beliefs rely on claims of a divine authority that are not simply shared by all persons, and hence some say it is lawless to use them in public political debate. These people say God's will, whatever it may be, has no more authority than any other member of the political community. The political community, in that sense, protects the right of every human being to deny God's authority. One person once explained that to me, the eternal right to be eternally wrong. God, or those who would uphold God's authority within the political community, for some people, therefore, become lawless in this view. Consequently, to be heard and judged to be lawful by legal positivists, it is best to be able to cite public reasons. Never go to law without public reasons, no matter how motivated you might be by the revelation of Jesus Christ. I think of Isaiah In the day King Uzziah died, I saw a vision of the Lord, and it motivated Isaiah all of his life. But he had very public reasons for why Israel should not get involved with Egypt. On the other hand, the natural law tradition finds human will, whether each of an individual or of a community, far too arbitrary a means to constitute a foundation for either a political system or even a particular law. Without knowing it, most people that are pro-life are partaking and drinking of the cup of natural law. Thus, Noonan is horrified at the positivist result, quote, that there is no kind of human behavior that, just because of its nature, could not be made into a legal duty corresponding to a legal right. He's reflecting most specifically on the fact that no one in the German Reich was violating any positive law of Germany at the time they participated in the Holocaust. That was their principal defense. The natural law tradition grounds all law in reason, which is understood as participating in the moral law of God as revealed in nature. In this view, the good precedes the right. And hence there is no right to choose evil or to define that which is by nature evil as good. A strictly positivistic system is thus, in a natural law theorist's mind, a lawless system, particularly when its laws contradict the natural law. An unjust law is no law at all, regardless of the will of the individual or the community. Judging how the law will shape our life and death decisions is complicated. Some would say made impossible by these contradicting visions of lawfulness and lawlessness. I remember a professor, Arthur Leff, used to put the paradox this way: what people want is a perfect set of findable rules that always work, and simultaneously and at the very same time to be perfectly free. If you think we are an oxymoron, we represent a paradox. Natural law and evangelical interpretations of law perceive Roe as lawless in several senses. Let me describe them briefly. First, Roe makes a seriously harmful act contrary to the higher law into a right, and thus trumps both reason and good by the arbitrary will of each pregnant woman without any due process of law. Second, Roe itself is an arbitrary act of the Supreme Court justices which subverts the law of the Constitution through the arbitrary will of the justices, and hence makes all future law subject to the same subversion. This is the biggest problem we have when we do pro-life public policy. People having lost their moral sense or their natural law sense only look to lawyers and laws and the latest Supreme Court decision to tell them what is good. But what they're really getting is what is rights, not what is good. And they confuse them. And our children that are just learning to live in a Republican form of government totally begin to believe that that moral and legal are the same thing, when they're in fact totally different conversations. That confusion is used to the death of many in our country. Third, Roe fails even under positivistic terms because it sets aside the autonomy and human being of the unborn child, the fetus, the human embryo, the undifferentiated blob, whatever you want to call that human being. This argument can be elaborated, I think, through a demonstration that the Supreme Court's most recent abortion decision, Planned Parenthood versus Casey, has evidenced an increasing lawlessness, which is just currying disrespect, not respect for law. The law that theoretically empowers the justices to invalidate the acts of the political branches of government is supposedly the Constitution. In Casey, the joint opinion specifically rejected the view that the justices, in interpreting the Constitution, are limited by the history and traditions of the American people. That comes as a surprise to most audiences who revere the Constitution and think that the Supreme Court of the United States believes that it's bound by it. Instead, the justices believe themselves free to apply their, quote, reasoned judgment in interpreting the Constitution, even where such methodology leads them to reject the original understandings of the generations that framed and lived under the Constitution. The justices, in short, claim the unlimited and undefined authority to change the meanings of the document, which is the basis of their own authority. Such a claim of authority itself can appear lawless, as the Constitution can become anything that a majority of Supreme Court justices believe it to be. America becomes, in that sense, a nation of men. I might add lawless men and women, and not of laws. The joint opinion's response to this apparent lack of lawlessness was, in fact, to grasp even more power to assist the appearance rather than the actuality of lawfulness. Thus, the authors of the joint opinion claimed that they should not, based on a mere change of membership, overrule even an erroneous decision. Can you imagine what your children would think of their parents if their parents couldn't even overrule an erroneous decision, or what you as parents would think if you couldn't overrule even an erroneous decision of your children? Such overrulings, particularly where the membership changes were themselves a product of a political movement, said the court would make it appear that the law was based merely on the membership of the court. Thus, the joint opinion affirmed the actuality of lawlessness, that the justices have the power and the right to change the meaning of the Constitution and then to claim the further right to hide this actuality by maintaining an appearance of lawfulness. Such disrespect for the Constitution will only curry further lawlessness. A theory of judicial interpretation that permits the justices to cast aside original and long-standing historical understandings of the Constitution based on their own reasoned judgment undermines even the concept of an erroneous decision. The capacity of the Constitution to change with reasoned judgments of the court's members suggests that all judgments are correct when made, something that never otherwise corresponds to reality in human experience. Error is another word for an outdated rule now, and is used when the current members of the court care enough about an issue to overrule their predecessors. The rule of law in this understanding becomes merely a prudential admonition to maintain the appearances of lawfulness, not lawfulness itself. The Casey joint opinion admits that the viability line has received, quote, much criticism, and they even admit that it seems, quote, arbitrary, end quote, and that Roe's balancing of the woman's right with fetal survival may be wrong, but they nonetheless reaffirm Roe's fiat. Both Roe and Casey claimed to avoid, and this is important, deciding the moral status of abortion or of the fetus, and they thus claim to avoid the moral or natural law questions raised by abortion. Thus, the central conflict between the women's liberty and fetal life is never addressed in serious fashion in either Roe or Casey. Let me repeat that. Hello. Good morning. The central conflict between the woman's liberty and fetal life, although briefed by everybody under the sun, strangely, in neither case, is addressed in serious fashion. We are in denial, folks. Under these circumstances, the court's claim of authority to use reasoned judgment in interpreting the Constitution appears to constitute an assertion of raw power to decide controversial public policy questions by invoking the Constitution. How convenient. The Constitution becomes kind of a seal of authority for whatever pronouncements the court wishes to make. It should be remembered that Roe was criticized not merely because it is bad constitutional law, but rather, quote, because it is not constitutional law and gives almost no sense of an obligation to try to be. Casey further undercut the court's sense of obligation, quote, to trace its premises to the charter from which it derives its authority. This, of course, really beefs Christians because we, of course, have been taught from the time we were little that we ourselves are under authority. And as a word-based people, it gives us a lot of pause for concern when we think we live in a word-based country where the word itself is ignored or manipulated beyond recognition. Thus, Casey stands as the most genuinely existentialist opinion of the Supreme Court. The joint opinion went beyond a rhetorical and doctrinal embrace of existentialism to the ultimate existentialist act of embracing the court's absolute power to recreate itself and the Constitution in each decision. Superficially, the court appeared to declare itself bound by precedent, but on the deeper level, the court declared itself free from the shackles of text and history and tradition and bound by precedent only when and if it chooses to be so bound. The only limitation the court truly acknowledged was the need to maintain its own power and reputation by providing society with a minimum degree of continuity and stability within these broad bounds. The court could freely recreate both itself and the Constitution otherwise. And this is, I think, what Sir Brian was indicating last night, that often behind our constitutional decisions and our essential rule of law appearances, often ego is desperately involved. The court solipsistically declared itself as the primary referent of its decisions. The court's obligation to itself overrode any obligations to the historical Constitution, higher law, or the lawful acts of the political branches, or even much of an obligation to even explain why. The court justified such an orgy of self-absorbed power by declaring itself to be the virtual ground of being the nation. The country's belief in itself would virtually collapse, suggested the joint opinion, if its faith in the court was somehow undermined. The court, we discover, is the savior of the nation. Thus, Casey usurps the democratic process and seeks to lull people into the false view that life is not an inalienable right as stated in our Declaration of Independence, but it is a malleable classification to be ultimately determined not by the people, but if at all, by the Supreme Court. And certainly not by the people through our elected representatives based on scientific facts that correspond to reality. This lawless usurpation ought never be permitted to go unchallenged, ladies and gentlemen. While any number of legal strategies may be proposed to ultimately overturn Roe and its progeny, I have spent a long time on it so that you would know the gravity or the size of the legal boulder we are trying to move. However, one way we can resist Roe and Casey now is by establishing as a scientific fact the humanity of the human embryo and defending its right to life before it is either implanted in the womb of a woman hostile to its continued existence or donated for destructive human embryonic research. Such a defense begins by understanding how the existence of a growing number of frozen and unchosen human embryos are being used as the essential justification today by the National Institutes for Health to cynically ignore the existing federal funding ban on the destruction of human embryos and proposed the funding of research on embryonic stem cells that can only be obtained by thawing and killing these embryos, and then engaging in the longement that they didn't really kill them, somebody else killed them, and then delivered them to them for the research. Where did these embryos come from? Well, I just don't know. Let me tell you, as recently as yesterday, reading from the press secretary of the Clinton administration, their press release just yesterday. The Clinton administration recognizes that human stem cell technology's potential medical benefits are compelling and worthy of pursuit, so long as the research is conducted according to the highest ethical standards. It all depends what you mean by highest. NIH is putting in place guidelines and an oversight system that will ensure that the cells are obtained in an ethically sound manner. Notice, see, America will never understand it, that the cells are obtained in an ethically sound manner. No mention of how the cells were obtained before they were purchased. The President's 1994 ban on the use of federal funds for the creation of human embryos for research purposes will remain in effect. So far, so good. No other legal actions are necessary at this time because, and get it now, it appears. It all depends what appears means. Because it appears that human embryonic stem cells will be available from the private sector. What are they referring to? 150,000 frozen and unchosen embryos, right? Publicly funded research using these cells is permissible under the current congressional ban on human embryo research. False. Not true. No correspondence with reality. Despite its high costs, practical uncertainties, low success rates, and physical difficulties, a growing number of infertile couples who cannot naturally conceive offspring now choose in vitro fertilization. I don't want to push a point too far here. I myself have struggled with this issue. But now that we have 150,000 frozen and unchosen embryos, it has created for the bureaucrats and for those who want to advance research at any cost, a very attractive source of stem cells. We lawyers might go so far as to call it an attractive nuisance. But it's not a nuisance. Far from a nuisance. It is our brothers and our sisters. It is the next generation waiting for a place to be warm. With the advancement of IVF technology, particularly the fact that fertility drugs given to women in IVF programs sometimes produce more embryos than can safely be implanted at any one time, it has become quite common to freeze the unused embryos for later thawing and implantation in a process known as cryopreservation. Although this cryopreservation process may relieve the woman of the cost and physical burden of further egg retrievals in the IVF process, while temporarily preserving the lives of the frozen embryos that would otherwise die for lack of implantation, it also brings along with it troubling medical, ethical, and legal issues, particularly when the parties divorce, die, or disagree about the disposition of the frozen embryos during that lengthy period between the fertilization, when the human being becomes a new, unique human being, and implantation, which cryopreservation preserves. The period could be as long as 5 years. I would now like to briefly review these issues and make a legislative proposal consistent with current constitutional law that resolves these issues in a manner most protective of life. It has been the historic purpose of Christian Legal Society, when we get involved with an issue, to think about an issue for a long time and then come up with an idea and then stay on that idea like a junkyard dog until it comes into law. This is the idea. But let me describe the current situation. There are more than 10 million infertile couples in the United States. In the last decade, the infertility industry has grown from only 30 clinics to over 300 clinics, earning revenues in excess of $1 billion a year. It is estimated that in the United States, in 1999, more than 75,000 infants will be born as a result of IVF. To put that in perspective, that is more than twice as many as will be available through traditional adoption. At the same time, more than 150,000 human embryos are now frozen, suspended in liquid oxygen tanks, with more than 19,000 more frozen embryos estimated to be added each year. Dr. Jerome Lejeune referred to these tanks as the concentration can. Yet while there are pages of adoption laws in the books in each state, only 9 states, Louisiana, New Mexico, Florida, Pennsylvania, Kentucky, Kansas, Virginia, New Hampshire, and California, have enacted some legislation relating to IVF, and only 3 of these states, Louisiana, New Mexico, and Florida, regulate the disposition of the embryo in any way. Consequently, in most states, the fate of most frozen embryos is left unpredictably open-ended and undecided, a victory for the libertarians. The only federal law related to artificial reproductive technologies like IVF is the Federal Clinic Success Rate and Certification Act of 1992. It neither governs nor regulates the disposition of frozen embryos, nor are there any federal court cases establishing federal law on the subject of frozen embryos. Other countries, such as Great Britain, have addressed this dilemma by instituting a law mandating the destruction of any frozen embryos that have been in a cryopreserved state for over 5 years. In 1996, appalled by the imminent mass destruction of thousands of frozen embryos, the Vatican responded by suggesting, quote, that married women volunteer to bring the embryos to term in prenatal adoption. At the time, there were approximately 9,300 fertilized embryos subject to destruction under the law. We might think biblically of the Jewish children in ancient Egypt. At the time of these 93 embryos, the clinics were able to reach the parents of 6,000 of the embryos who exercised their rights under the law to extend the storage for another 5 years, donate the embryos for research, or give them to another woman. The 3,300 remaining potential infants, in the words of the law, in a chilling reminder of another Holocaust involving persons considered by their Nazi executioners to be subhuman, were thawed out, destroyed with saline solution, and incinerated with the other biological waste. In Australia, the Infertility Treatment Act of 1984 has time restrictions similar to that of Britain, with the possibility of extension for reasonable grounds. The act requires that when implantation in the woman donor is not possible, the embryo should be made available to another woman with donor consent. The embryos can be destroyed if the donors do not consent or withdraw their consent in writing. However, where the donors cannot be contacted, the government has the authority to order the hospital where the embryo is stored to implant the embryo in another woman. Interestingly enough, of all the countries in the world, which country do you think avoids the problem entirely by prohibiting the freezing of embryos? Germany. The only place where a group of people who have actually experienced this correspondence to reality before, bar it. Interesting. I have an article here from the medical journals that was given to me by Dr. Eskeplius here. It says this, quote, in Erlangen, the freezing of human embryos began in 1983 and ended in 1986 as, although the technique works successfully, we wish to avoid the problem of an increasing number of orphaned frozen embryos. It took until 1990 to transfer all the stored embryos to the patients from whom they originated. The time taken for the transfer reflects the difficulties we encountered in convincing the couples that these embryos had to be transferred to them, because discarding or donating the embryos was not accepted by German society. In Germany, society, quote, as represented by print media and television, end quote, does not accept embryo cryopreservation or assisted reproductive techniques which manipulate human life. So don't let anyone argue that it's not humanly possible, folks. It is being made possible by the people who were more inhumanely involved than any other nation in the world. Since 1978, when the first IVF baby, Louise Brown, was born in Great Britain, courts have also decided issues related to frozen embryos in cases such as Del Zios versus Columbia Presbyterian, York versus Jones, Davis v. Davis, the most famous frozen embryos case in which Christian Legal Society was involved, and Cass v. Cass. Time does not permit me to go into great detail, but let me just try to summarize. At present, relying on various rationales for their decisions, the general trend has been for the courts, lacking any real regulatory guidance, to side with the party seeking the destruction of the human embryos, either on contractual grounds or on the ground that the interest in avoiding procreation trumps all other asserted interests. The cases essentially turn on two questions. What is the legal status of the frozen embryo, and ought this status be determined by the gamete providers as a matter of private contractual law or by the state as a matter of public policy, particularly when the gamete providers either disagree, die, divorce, or otherwise unavailable. Regarding the status of the frozen embryo, remember, which is existing out of the uterus now, and we don't have the conflicts with the liberty interest of the woman, we have basically four theories. First, the human life theory, that the frozen embryo is a human being deserving the equal protection of the laws against homicide. Two, the pure property theory, that the frozen embryo is merely property to be dealt with under common law contract and personal property principles. Three, the special status theory, that the frozen embryo deserves special respect as against the claims of the non-gamete providers, but not really possessing rights sufficient to limit the procreative or contractual rights of the gamete providers themselves. And finally, the so-called constitutional rights theory, based upon ill-conceived analogies to distinguishable Supreme Court right to privacy decisions protecting abortion and contraception. This theory basically says that a gamete provider does have a right not to procreate that trumps any constitutional, statutory, contractual, or any other right against the destruction of the human embryo prior to implantation. Each theory has its proponents and its critics. Those who hold that the embryo is a living human being, as I do, seek protective legislation like the laws of Louisiana and New Mexico permitting, quote, prenatal adoption of frozen embryos and prohibiting the intentional destruction of human embryos. Such proponents also support judicial application of the best interests of the child standard for determining which of the gamete providers ought to have custody of the frozen embryos, regardless of any written agreements the gamete providers may have to destroy or donate the embryos for destructive research. Based upon Dr. Jerome Lejeune's expert genetics testimony calling the human embryo early human beings or tiny persons, and equating the destruction of a frozen embryo with death from a concentration can, the trial court in Davis v. Davis adopted the human life theory and gave custody to the mother who wished to preserve the lives of their frozen embryos over her husband's desire to destroy them because they had subsequently been divorced. Moving right along, and I can see Mr. Moscato back there, let me just make my proposal. Based upon the unpredictable, inconsistent, and unduly costly results described above in the courts and in the law generally, it seems that all the courts and the commentators at least uniformly agree about one thing. On the federal and state levels, we should adopt a legislative framework regulating the cryogenic preservation and implantation of human embryos. Unfortunately, many of the proposals ignore the humanity of the human embryo by recommending that human embryos be likened to property, not people, with no protectable legal interests of their own. In opposition to these proposals, the following elements of a more life-protective proposal of law regulating the cryogenic preservation of human embryos on a current and a prospective basis is today proposed. First, as already established in 38 states, the life of the human being would be expressly acknowledged as a scientific fact to begin at fertilization or conception. Second, as already established in Louisiana, the ex utero human embryo would be deemed a juridical person, entitled to pursue its continued development until its term in the organism of its biological or adopted mother. If IVF patients, quote, fail to express their identity or renounce parental rights, the physician is deemed to be the embryo's temporary guardian until an adoptive implantation can occur. As already established in New Mexico, human embryos can only be disposed of through implantation, not intentional destruction through destructive human embryo research. 4, prospectively, the cryopreservation of a human embryo shall only be permitted as needed to preserve its life until implantation can occur. 5, the pursuit of its continued development until its term in the organism of its biological or adopted mother must be offered to each human embryo before another embryo may be conceived. 6, and as already established in Australia, existing cryopreserved human embryos may only be thawed and allowed to deteriorate after 5 years, if and only if the gamete providers do not earlier consent to an extension of this time or to their implantation in the organism of the biological or adopted mother, and no one can be found by the custodian of the human embryo willing to accept implantation of the human embryo and assume parental responsibility for it. The church needs to come in there. Agreements for the destruction of a human embryo or the donation of a human embryo for biological or medical research not designed to evaluate, protect, or restore the health of that embryo shall be unenforceable as violative of public policy and not entitled to government funding of any kind, no matter what the NIH says. No human embryo, number 8, can be intentionally created for or submitted to any exploitation whatsoever, including being created for any investigational research purpose not intended to diagnose or improve the life or health of the embryo or individual biological parent, and which result in the destruction of the embryo. And then finally, prior to any IVF procedure, all IVF providers must obtain the gamete provider's signature on a written disclosure form and a dispositional agreement that fully informs the gamete providers of the law requiring the implantation of all human embryos so conceived, as well as the costs, risks, and probabilities for success involved in IVF procedures being used, and the time for deterioration of cryopreserved embryos should such preservation be necessary to maintain the viability of the cryopreserved embryos prior to conclusion, to its implantation. You have heard already that on Thursday, July 1st, the Center for Bioethics and Human Dignity publicly released its statement in opposition to human embryonic stem cell research during a press conference in Washington, D.C. The reason is that such research indubitably and inevitably requires the destruction of the human embryo. Please read the statement and sign it. We have now gone further to form a group called Do No Harm, the Coalition of Americans for Research Ethics. The initial objectives of Do No Harm, which we hope will grow to be a quite large national group supported by people like yourselves and friends that you might recruit. The first two objectives are to support the development of medical treatments and therapies that do not require the destruction of human life, including the human embryo, and also to support the continuation of the federal law prohibiting federal funding of research that require the destruction of human life, including the human embryo. Please support this work. As recently stated in Christianity Today, the coming battle over research in human embryos promises to be a defining moment in bioethics and is a struggle that should engage those who truly value all human life. I trust it shall engage each of you. As it does, be inspired by the words of the Dutch Christian reformer Abraham Kuyper, who said, "When principles that run against your deepest convictions begin to win the day, then battle is your calling and peace has become sin. You must, at the price of deepest peace, lay your convictions before friend and enemy with all the fire of your faith." And be inspired by this truer picture of Lady Justice. This picture hangs in the courthouse in Zurich. It was painted during the time of the Reformation. Notice this truer picture shows Lady Justice, now unblinded, her sword pointing to and guided by what our founding fathers knew to be the law of nature and of nature's God. As Lady Justice lifts the nations. Thank you for listening as I've laid some of my deepest concerns and proposals for actions before you. I will now leave you to make a difference with all the fire of your faith.